third day session on this webinar series on Indian Patents Acts, and our esteemed speaker today is Dr. Sanchita Ganguli. She is from Majumdar IP, and in fact we already have heard him during our patent drafting workshop webinar series. And now today she will be speaking on anticipation under section 2934 of Patents Act 1970, and she has great deal of experience in prosecution and other patent drafting at Indian Patent Office. So I would like to request Dr. Sanchita Ganguli Madam for her presentation.
Thank you, Dr. Sivarkar, and welcome all of you. Good morning on a Sunday morning. So might be not so interesting to be here at the Sunday morning studies and Sunday. Anyway, this is some sort of fun also doing it from home. So with that, I'll just go in, and as I'm told that you have had some experience in and have been this workshop is being going on for some time. So you all are having some experience, some knowledge of the Patents Act and how to draft and how these are going on. So let me just go into the nuances of, or shall we wait for some time? There's 7 people waiting. Very good morning, Sunday morning. We start with this session. Sorry. Now, you must be knowing what is a patent. So let us just look at it once. That a patent is a grant by the sovereign or state to a person giving right to exclude others. So it is a negative right. It gives the inventor or the person who is deriving title from him to exclude others from making, using, selling, or offering for sale an invention for a limited period of time. And what is the quid pro quo is that in return to the monopoly which the government or the statute gives to the inventors have to disclose the invention. And so that is what a patent specification is. You make an invention and you disclose it, and for that invention, if it is meeting the criteria of patentability, patent is granted, and for which you are supposed to disclose the invention so that the general public can use the invention after the monopoly is over, and within the monopoly time period they can also use it, but with your permission. Without the permission nobody can use it. So it is a negative right, while the owner has the qualified right to use the invention. Now, if we see what is patentability, or that for what a patent is granted is an invention which is novel, inventive, and capable of industrial application. Now you all, these are the 3 cardinal features on which the whole patenting or the statute or most of the countries, they base the basic features as this, that the invention should be novel, the invention should have industrial applicability, the invention should be inventive. Now along with it, there are certain statutory exclusion. Now, why do we have the statutory exclusion? That is because of the fact that every country has its own way of looking into things, and most importantly, the economy of all the countries are not the same. So accordingly, we have certain statutory exclusions in different countries. Now, in earlier days, that is before 2002, we even didn't have the criteria of inventive step into patentability. So it was only a new product or manner of manufacture which was having industrial step. Why? Because the lawmakers realized that at that point of time, when India was in a formative state after independence, they were not so much active or so much capable of making such inventions which also meet the criteria of inventive step. So this had come in later. And then before 2005, we had statutory exclusions which included that no product would be granted for patent in the field of pharmaceuticals and agrochemicals. Why? Because the time was given to the entrepreneurs, to the industry, to the institutions to develop their then with those, what should I say, that with those experience, then later so that they can make a new product by themselves and which could be protected. So the protection of the products came in later in 2005 when it became totally compliant with the international laws. So if we go to the next slide. Now, these salient features of novelty, inventive step, and capable of industrial application, these are the factors or the features which play role always when we are looking into the invention. That is, while we are drafting the patent application to be filed, and so while drafting, we have to keep in mind that these should be novel, they should be inventive and capable of industrial application. Now, then during prosecution and examination, these are the features or these are the qualities or these are the characteristics of the invention which are tested by the examiners. Then these are the grounds for opposition. These are grounds for revocation. So you see, there are, because it is a monopoly being granted, there are so many barriers, like so many checkpoints, so that no bad patent is granted, or that whichever patent is granted should be novel, inventive, and having industrial application. Now, with this, if we go to see what novelty is. Now, first criteria of patentability is novelty. The idea is that a monopoly is given to the inventor or somebody who's deriving title from him. He should make something which is new. And the main idea or the main feature or the whole process of patenting and patentability is to encourage so that new things are developed. People, the scientists, they entrepreneurs, the researchers, they are able to develop or they are encouraged to develop new products and processes which were not known. So that is the incentive given to them. Now, when we say that it is novel, so what is, how do you check that it is novel? So the idea of checking a novelty is to see whether something is done before. So you bake a cake and you say this is totally novel. So what is the newness in it? Because you might have added something which usually people do not add into the batter for baking that. So that makes it new. So how do you say it is new? Because you compare it with something which is already there, which is old. So now how do you compare or with what you compare? Now, to say something is old or something is available, how do you say that it is available? Okay, so when Columbus went to America, nobody had gone there before him. So the idea is whether it is published before him or just. So under what circumstances is the novelty lost, or what do you compare with to find whether that invention is actually novel? So you can compare with prior publication, you can compare with prior public use, and you can compare with prior public knowledge. Interestingly, it should be made available to the public. So prior publication. Publication could be anything. It could be a photograph. It could be a paper which is publicly available. Now it could be lying in some obscure library somewhere, say in Jordan. That doesn't make it that it is not available to public, because people hardly visit that library or hardly read that paper or that compilation. So the criteria is it was available to public. So even a single unfettered person who is aware of it can be taken as a publication, prior public knowledge. So there was a case where a pen was gifted to somebody, and then without any requirement of confidentiality, and then it was applied for patent. Now it was said that because this particular person had the knowledge and he was free to disseminate that knowledge to the public, so that is pen is no more novel. So the prior publication, prior public knowledge are very important aspects. Now public knowledge could be not only through publication, not only through any print media or any PPT presentation in the public. It could be general knowledge in certain area. And what is prior public use? Prior public use is use in public. So it has to be used in public. Now, there was a case where a lock which was present in a gate of an old building, that lock had taken away the novelty of a patent applied later, because that lock was in public use, because that lock was in use in a gate of a building which was not used by anybody. It was lying there in public. So people knew about its use, and accordingly that was not prior public use. However, for public use, you do not take in secret uses. Like somebody had made a locker in his house to keep stack money, but that was not disclosed to anybody. Now, that sort of a locker cannot take away the novelty of something which is later applied for a patent, because that use was not in public, or it was rather a secret use. Now, prior public knowledge is the knowledge which is available to the public. It's like you sprain your foot or you sprain your leg and you apply haldi and chuna, and that has been done from ages. I mean, our grandmothers and their grandmothers also use such things. So that is available in the public knowledge. Now, as I was just saying that the prior art, what we call prior art, is the documents which are prior, that is before the priority date of the claim of the invention which is being analyzed or which is being adjudicated. So it could be published anywhere in the world and in any form. As we said that even a photograph can act as a prior publication. And the public use is, prior public use is only in India. So it is confined to the use in India. Now, there could be traditional knowledge in India. That's also very important, because now if you see, if you try to patent a concoction made of say honey, ginger for sore throat, and that is not patentable because that's traditional knowledge. People know that these are used for such purposes. And as we said, the document and the knowledge should be in public domain. Now, let us see the criteria of novelty. It says that an invention is considered new if it does not form prior art. So prior art is what? Prior art is all the documents that is available prior to you. So as we were discussing, it is published in a document in India or elsewhere. It's prior used in India. Prior public knowledge could be in India or anywhere, and that knowledge could be in the form of a printed material or knowledge passed down through generations. So that could be there. And there is something called unpublished prior art, and the criteria for that is different in different jurisdiction. In India, we use it as prior claiming statute, even if come from section 13, where it says it's claimed in a claim of a complete specification which is filed before the priority date, but it is published on or after the priority date of the present invention. So there what we have to do, we can only compare claim versus claim. Now the idea is that patent is granted for one invention. So if your claims or the monopoly is same as that of somebody else's who's already done it, so then the patent office cannot grant, or the statute cannot grant two patents for a single invention. Now the idea is, how will you know? Because it was not published. That is the reason only the claims are seen, or only claims are considered, rather the whole specification. Now if we see that how this test goes about, says that the novelty is destroyed when one single document unmistakably teaches the claimed invention. So it has to come from one document. And even the document which is cited as a prior art in that particular, like your invention is being said to be not novel in view of a document A, and in that document A there has been citation of document B. So there the combination can be done. So that also forms part of the same document. It's like say the prior document says that your invention is in a stapler, and the prior document says about a stapler which improves the pressability of the stapler over a prior art which had certain features, and the improvement is brought about by more features. So your prior art A has features A, B, C, D, out of which A, B are features of its prior art and C, D are its improvement there. So the whole of A, B, C, D features will be considered against the stapler which you have invented, and also for this purpose, that is for increasing the pressability or smoothness of pressability, so that more staples can be done in a faster time, in a short time. Now the other thing is that for novelty, adjudication of novelty, or to make a application or the patent claim as anticipated, each and every element of the claim must be present in a single document. If one element is missing, the prior art does not anticipate. Now the example which I was just saying, ABCD is there in the prior art, and you have done the stapler ABCDE where the E factor is not there in the prior art one or its prior art. So in which is already that prior art already referred there and incorporated in this. So then your invention is not anticipated. But even if the prior art says that it is optional, still you will have it. That optional feature will also be considered when adjudicating the novelty of the invention. So if we see pictorially, if the prior art is here and your invention is the red one or maroon one, then you are quite far from the prior art and your invention is novel. On the other hand, if this is the yellow part is the prior art and your invention is within that prior art, then it is not novel. But consider a situation where this red portion is here, which is slightly overlapping. So what you can do during prosecution, you can chuck off the overlap portion and bring it here so that it becomes novel, but inventive step is a further question which has to be adjudicated later. Now, if we look at this case, this is a very important, interesting case we had for opposition. Now, this is the invention where the invention is about a comb in textile machinery. Now, it does the same thing which a comb does to the hair. What does it do? It is like this. It has teeth like the comb, and it sort of, what should I say, sort of combs the fibers so that the fibers, the uneven fibers are chucked off and only the even fibers remain. So this combing was such that the Just give me a moment. If I is here, I cannot. Just give me a moment. Sorry. Here, if you see the first portion here, the teeth are larger and they are spaced apart. And then they are progressively, the spacing is reducing. So that's what their invention is. They're saying that the initial portion of this is a round sort of a comb. Initial portion, these portions of the comb are such that the teeth are wide and the teeth are larger. And this portion is small. This alpha portion is small. The next portion is beta portion. The portion is big, but the teeth are smaller and they are spacing between the teeth are less. Next is a gamma section, alpha, beta, gamma section, where the teeth are still smaller and the spacing are decreased, but the area is more. And the last one, the area is largest, the teeth are smallest, their spacing is least. So it is progressively the teeth become smaller and the spacings becomes less so that it is able to comb well. Now for this, we found a German document. It was actually a patent document, but we had no translation. So we could depend on whatever was taught in the specification of that document. But the figure was very apt. If you see the figure, you see this is the first portion. Here the teeth are larger, spaces are more, and if you see subsequently the teeth sizes are coming down and smaller and smaller, and the spacing is reducing. So it clearly one can see the changes. So you don't need a write-up to describe this. It is evident that this it teaches the same properties as to the progressively reduction in the size of the teeth of the comb, progressively reduction in the intercomb spacing, and the increase in the overall area of that particular type of. See, if this area is much smaller than the area which has the smallest number of combs. So it was evident that this photograph or the drawing teaches the invention which was under opposition. Now we were asked by the controller, okay, fine, I can, but we have never had such cases. You can, if you find any case law, show me so that I know. I mean, nobody wants to take it on them. So show me in any document or any case law where such things were taken into account. So we found a case law in European case law where it says that features solely shown in drawings form state of art if skilled person is able to understand the description and all the technical feature even in absence of the description. And another case law was cited where the drawing forms prior art of disclosure and even in absence of clarifying written disclosure. The skilled, as long as the skilled worker is able to decipher the features. Now here what we said show is one can clearly see that those features of the present invention are available in the prior art. So it was held that drawings to be considered as prior art even if sufficiently and clearly and understandable describe the features of the impugned claim to a person and provides enabling disclosure. So it is an enabling disclosure and accordingly it is anticipated. Now another piece. Now why we are discussing these cases is because what I'm supposed to talk here is what is not considered to be anticipatory, because that's what section 29 to 34 says, that what is not considered, the exceptions to what are considered as anticipatory. So to know the exceptions, we should first understand what is considered as novelty killing documents and what is not, and then we find out that what are the exceptions for that. So this is a case where the prior art, the claimed invention was a high-speed cigarette-making machine of tobacco, which showered vertically piling, to prevent vertically piling of the tobacco. They gave a forward motion to the nozzle from which the nozzle is there and the tobacco leaves falling, and what they gave a forward motion to that nozzle so that they fell on a paper in some angle. And what did the prior art teach? The prior art was for a slow cigarette making machine, but they had the trough which was inclined. This was straight and the trough which was inclined. So if we just see pictorially, here the prior art, the nozzle was straight, but the trough on which it was falling was inclined. The tobacco was falling vertically, but the trough was inclined. So there was an inclination angle. What is the invention or the claim? The claim was that they were to fall vertically, but because they used to pile up here, what they gave a forward motion so that they don't pile up. So this is going on this way. So, but if you see in effect, this is kept straight, the trough in which it is falling, but the angle is maintained. So there is an angle which is on to the horizon. So in effect, if you see here also there is an angle formed, here also there is an angle formed. How it is formed is not important as long as the angle is formed. So Bosnack deprived Mollin's claim 1 of novelty, though he is not concerned with the problem to be solved. So Mollin's claim could be said by restricting to a cigarette making machine. So they could have incorporated these features in claims, like we were just telling when we were pictorially showing that your invention is a smaller one here and the bigger one is the prior art. So if it is away, it is not anticipated, and if it is slightly overlapping, you cut out the overlap portion so that it becomes known. So here they could have restricted it to say that it is a fast cigarette making machine, it could make so many cigarettes. So those features were not there in the prior art. However, the claim was not restrictive. The claim only had that it has to give a forward motion so that it fell at an angle. So that feature, which was supposed to be essential to the claim, was taught in the prior art. But these additional features which they could have incorporated in the claim to save it were not there. So if the prior art falls within the boundary of the claim, no monopoly can be claimed. It is immaterial if the earlier or the later work approached from different standpoints. So here the prior art had nothing to do with piling up of a cigarette, or it is nothing to do with the fast moving cigarette making machine. But in effect, they came the same because the features which are there in the claim, when considered against this prior art, were found to be totally falling within. So only subjectivity, a step forward compared to a prior will not suffice. Alleged invention should be for objectivity also. Now, this case perhaps many of us know. It is one of the very important cases. You will find it often cited in various case laws. This is Merrill Dow Pharmaceutical versus the Norton. Very interesting case. Now, what happened? Merrill Dow first patent was for a drug terfenadine, which is an antihistamine, which is metabolized in liver. And it said that it is metabolized in liver and that was responsible for its activity. So that was the first patent on terfenadine. Now they had a second patent which was filed 9 years prior to the end of the term of the previous patent. And there what they claimed is the acid metabolite of so they claimed here the acid metabolite of terfenadine and filed this patent. Now, that was done 9 years before. So by the time the first patent, which is for the terfenadine, ended, the second patent for the acid metabolite was still alive. Now, after the term of the first patent, Norton, they manufactured terfenadine.
Ma'am, what was the acid metabolite? Could you just repeat that again, the first and second points, just once more? I mean, I missed that.
Okay. Now, Merrill Dow is a pharmaceutical company. They had a patent on a drug, terfenadine, which is antihistamine. We all have taken such drugs for the allergic rhinitis and any small allergies. It's a very common drug, terfenadine. This is the drug and how it acts is that it goes to the liver and there it is metabolized, and that metabolized portion is, or the metabolized drug is the one which is giving the respective activity or acting as antihistamine. Now, you know, these big pharmaceuticals, what they do is that they try to monopolize one after the other, because if they have claimed one thing in one patent, there are many downstream patents, so that with incremental changes, so that, you know, they can monopolize it for longer term. This can sort of extending the term, and that is what we in India do not allow by way of section 3D. But you do not have section 3D in US or UK. So like the reason, that's the reason the metabolites and what do you call polymorphs, these are not patentable in India unless and until you show that they have improved therapeutic efficacy. The idea is that you cannot prolong the monopoly. Now, this is the same thing which these people had done. So the first patent was there, and after 11 years they filed another patent for the acid metabolite of the same compound, that is terfenadine. Okay, now, so the terfenadine patent was there for 11 years, they ran parallelly. Sorry, for 9 years. Now, after this, 20 years term of the first patent was expired. Now, the second was still alive. Now, after the first patent expired, naturally, the terfenadine came into public domain. So, Norton, which is another company, they manufactured and sold terfenadine after this 20 years term of the first patent, the main patent terfenadine. So what Merrill Dow did is they went and sued Norton, saying that you are infringing my second patent, which is the acid metabolite patent, because you are supplying means to form the acid metabolite to the body. So my second patent is on acid metabolite. You are selling terfenadine, which ultimately will form acid metabolite in the body of the end users. So you are actually in effect infringing the acid metabolite patent. So that was the case of Merrill Dow when they sued Norton. Now, in counteraction, Norton said that this patent is bad, because you must be knowing that for infringement, what you have your ground to rebut is that either you say I am not infringing, or you say that the patent is bad. So the patent is bad patent. It is already available in public domain, and you cannot stop people from what they have been doing or they are free to do by a frivolous patent. So you cannot do that. So that's what they did. So what Norton counter claim for revocation? What was their counter claim for revocation? That this patent is bad, that is the second patent is bad, and it ought to be revoked because it is not new and is available to public by prior use of those who ingested terfenadine and prior disclosure in the specification of terfenadine patent. So they took two grounds of anticipation. One is prior public use and the other is prior publication. So now for anticipation through use, what the court found is that it is true that during the clinical trials, that is of the first patent, when the patent is filed, you must be knowing clinical trials are done much later because patent is filed very early. From an NC or a product to find it to be a drug and to come to the market as a drug, there would be at least 8-9 years, because you have to test it on the humans, you have to take the dose, then you have to go for clinical trials, then you have to go for the approval of making it. So it takes long time from the filing of the patent to the drug coming. So here the second patent was 11 years younger than the first patent. Now Norton said that within this 11 years the public had used it because they had ingested the drug. People have used the terfenadine, they have ingested it, and accordingly they have used the acid metabolite of the drug, which is the matter of the second patent. Now the court found that the volunteers, excuse me, the court found that the volunteers who are taking the acid metabolites in the livers, they didn't analyze it. They didn't know what is happening in their liver when the drug is being taken. Had they analyzed it, then they would have found that it is acid metabolite, and it would have been equal to reading a disclosure of acid metabolite. They took them to swallow, not knowing their composition and not identifying then, but now the composition is known to be an acid metabolite. So when those people, those volunteers had taken, they didn't know that this was the acid metabolite, and they just ingested it. So it was not used had they known that it is an acid metabolite which is working in my body, so that would have been my use in my body. And that since there were so many people using it, it would have been public use. But here, the volunteers just took it and they found the effect. They didn't know how, from what the effect is coming. They just knew because of this terfenadine, the effect is coming. That the terfenadine is metabolized into a particular acid metabolite, which is in the liver and which is giving this effect, they didn't know. So it was, or that they didn't use the acid metabolite in the body knowingly. So it was not an anticipation through use. But for the specification, the first specification, according to Merrill law, that the specification on terfenadine had no indication as to the effect of the creating of acid metabolite in the body, and the skilled reader would not know that the acid metabolite would be formed, and neither was the acid metabolite described with the formula or the structure. So we told you right in the beginning that the first sorry, I don't know how the sound was coming. Now, so according to Merrill, their first specification did not say that it is the acid metabolite in the body which gives the effect. It does not identify by its chemical structure, or it did not enable the public to know about the product from the description or to work the invention, and accordingly the second patent was novel. So what they said is that now in my first application of patent, I had said yes, it is metabolized in the body, acid metabolized, but I didn't say that it is the acid metabolite so and so which is giving the effect or which is acting, and neither was the compound structure disclosed. So it is not disclosed in the prior art or the first patent. Now, what the court found was that the volunteers, by taking terfenadine, produced acid metabolite in the liver and worked the invention irrespective of what they know or think about it. Because in the first patent, it was clearly said that a part of chemical reaction in the human body produced by ingestion of terfenadine and having an antihistamine effect. So the first patent clearly said that a part of the chemical reaction occurred in the human body when the terfenadine is ingested, and that gave the antihistamine effect. So, in effect, the acid metabolite has been described in the prior patent. Just because the chemical reaction or the specific chemical compound is not mentioned doesn't mean that there is no disclosure. There is disclosure by anticipation, and it was enabled also because these people actually, the volunteers actually took and it worked. So the enablement part is there. Now here it is very important to note that, so accordingly it was held that the second patent was anticipated by disclosure. So it was revoked, the second patent, because it was not anticipated by prior use, but it was anticipated by prior disclosure of the first patent. Now, if you see what happened here, the prior use conveyed no information as to enable working of the invention or making of the acid material. Now, as I was just going to say, what is so, and disclosure conveyed, whereas the disclosure that is the first patent conveyed to the public information as to enable working of the invention, that is the making of the acid. Now, there are two aspects of anticipation. One is disclosure and the other is enablement. Now, this was very well debated and taken in another very important case of Perexidine. Now, what is said is that it is not enough that you just disclose the invention. But in the prior art, it is disclosed, but it requires to be enabled also. Now, even in India, we had a case where in the opposition, this is a very lengthy case which was opposed after grant by 4 people. It was Valganciclovir and Frosh. It was opposed by Cipla, it was opposed by Bakul, it was opposed by Milan, and there was another team which opposed. So 4 people opposed it. In the first round, it was found to be not anticipated, but and not anticipated. Yes, the product, but not inventive. So it was novel, but not inventive. So the product was not allowed because it was not inventive, though it was novel, whereas the process was allowed. Now the opponents went to appeal because they wanted that it should be given as not anticipated also, whereas the patentee went for appeal to say that it is both novel and inventive. We remanded it back to the patent office. Then hearing was done in the patent office with all the documents, and also there was a requirement that some documents were not given to the opposition board. So it was again debated there, and this time it was very well put forward that anticipation is twofold. It has to be disclosed and enabled. In this case, Valganciclovir was valine. Yes, so Valganciclovir. So here, which is monohydroxylate. So there was one hydroxyl group, though there were 2 groups open for hydroxylation. And the patent on ganciclovir, which was already there, that told about that there were 2, actually it said about the 2 arms which could be hydrolyzed, and that they had hydrolyzed both. So hydroxyl bihydroxylated ganciclovir was that, and here it is valine ester of the monohydroxylated. And it also said that during formation, in the examples, during formation of the bihydroxylate, some monohydroxylate was also hydroxide was also formed. So it was argued that it discloses mainly the valine ester of ganciclovir, and though the prior art talked about the 2 hydroxyl groups, but it also said during forming of the 2 hydroxyl group, I mean both 2 hydroxylated valganciclovir, some monohydroxylated were also there which were discarded. So this document was both disclosing as well as enough. Now here also we find that the disclosure of the first patent conveyed to the public as to the enable working of the invention of making the. So it said that in the liver it is metabolized into the acid metabolite, and then it would give its effect. And that is exactly what the people did, that they took it and the acid metabolite was given. So naturally it was already disclosed in the prior patent.
Excuse me, ma'am.
Yes.
Whatever you are discussing right now, it's not matching with the PPT we are watching right now. So can you just check whether the right PPT is on display or not?
It is the right PPT in the screen. While describing enabling working, I just took another example which is not given in the PPT, which was another case where enabling disclosure was there.
Okay, I got your point. Actually, we were expecting the PPT for
No,
another case you were talking about. Thank you,
Yes,
ma'am.
yes.
Okay,
Yeah,
thanks.
it is just to show that how enabling working is also required. Enablement is also required. I don't have a slide for that. It is just for, I mean, to explain what enablement is.
Okay,
So
ma'am.
that's it.
Thanks. Thank you.
Oh. So here there was anticipation, no anticipation by use, but there was anticipation of disclosure. Sorry, just. So the use was solely relies on the acid metabolite, and no information regarding the formula or instruction. Ingestion of tafranidine is a chemical reaction in the body, and you do not need a description to be made. So that is what the anticipation and is by use and disclosure. Now we come to what is. Now we come to what is not anticipation, that is exceptions to anticipation, now which is taught by the sections 29 to 34, where it says that these are not, I mean, an invention cannot be, or a claim in a complete specification cannot be invalidated only because certain thing or certain criteria or certain conditions, under certain conditions, if the disclosure occurs under certain these conditions, they are not taken to be anticipated only by disclosure. So what are those grounds or the provisions which gives you exception or which gives you leverage or which tells you what is not anticipation? So first is the, if the claimed in the patent specification is anticipated by disclosure, the publication in the specification of an application for patent which is made before 1st January 1912. So if somebody finds that the invention has been disclosed in a patent in India which is filed before 1st January 1912, that is not considered as a publication which can jeopardize your novelty, or only if one document is there which is a specification filed for a patent application before 1912, just 1st January 1912, it will not consider as a anticipatory disclosure. Now the sorry, extremely sorry. Just give me a moment. Now the idea is that historically the first patent law in India was in 1856, and then it was amended 1858. Then 1883 full-fledged law came in, and then that was amended in and well structured in 1911. And the reason behind taking the cutoff date as 1/1/1912, as we find from Iyengar committee report, is that before that the applications were not printed, so one would not find. So the examiner also would not find a specification which is dated before this. So it's better that you leave it to that will not be considered as anticipation if only that document is stopped. Now the next is the previous publication is based on wrongful obtaining. Now wrongful obtaining, you might be knowing, that is also ground for opposition and revocation. Here, of course, opposition, revocation, the ground, the person is on the other side. And here it is in favor of the applicant. It says that if the matter of the patent specification is taken from him or obtained from him, that is, who is the first true and the first inventor, or the person who has the title, that is his assignee or legal representative, and was published without his consent. So I make an invention, and somebody who is perhaps working for me or working in my lab, without my consent, go and publishes it. I don't know. So when I file the application, and then he says, no, this is also published. So that publication will not be taken, because my invention is my invention, and this XYZ has obtained, or it has sort of taken away that without, and had it published without my consent. So that publication will not be taken as a publication which will anticipate my claims as claimed in my patent application. And also where the patentee or the applicant or any person, before the date of the application, in case of convention application, before the date of application for protection in convention country, that application in the convention country, as the case may be, was made soon after he realized. So what it says that when the patentee or the applicant, from whom he learns the publication before that the date has, that the document has already been published, and he goes to file the application immediately. So if somebody has taken it from me and published before I applied, and when I come to know about the publication, I go and apply for the patents, and reasonably that to show that, look, I didn't know he had taken it. And so immediately when I found that he has taken it, I have applied for the patent, and he has wrongfully obtained it. Now this is also applicable to convention applications, in the sense that, say in US, the inventor has disclosed, or somebody has taken it from him and went to publish it, and this person who is in US, who comes to know about it after the publication, and he immediately goes to file application in US. So this US application, and I sitting in India, I'm a sort of co-inventor or the same inventor files a convention application in India claiming priority from that US application. So that priority will not be lost, or the document which is published, the obtained document which is published by this obtainer XYZ from the inventor in USA and published in USA before filing of the priority document in US. So that publication by him of the invention which he has obtained and published without consent of the inventor in US will not be considered as a prior art for the convention application which is filed more than 1 year after the publication of the document, because the inventor, when he came to know in US that this publication has occurred after this person has obtained from him illegally and published without his consent, and he immediately went and filed the US application. So that application or that publication will not be considered as novelty killing or novelty destroying for the US application or the convention application claimed in, filed in it. Now, next is but this shall not apply if the invention was used by the inventor himself for commercial purpose other than for reasonable purpose trial, either by the patentee or the applicant or any person whom he derives title, or by other person with the consent of the patentee or the applicant or whom he derives. So these, now what it says actually is that somebody has obtained from me, I go and say somebody has obtained from me and I immediately file an application in India. But before filing the application, I myself go and work the invention other than reasonable trial, or I commercially use the invention or commercially work the invention, and then I file a patent and say that this person had already obtained from me and he has published, and so I should be given the leverage of this. It should not contain as prior art, considered as prior art. But then I am myself going and commercially exploiting it, and then I file it. So that will go against me. So it's fine that somebody has obtained from you and obtained from me and published without my consent. I didn't know. I go and file an application. Fine. But somebody has obtained, he has published, and I have also worked the invention. So I have also worked the invention and commercially work the invention. So I make prototypes and ask people to sell. It's not trial. I'm just finding how people are taking it just for commercial purpose. So I am violating, then I am disclosing it to the people before filing. So that will not be considered. Then this innocent, my innocence saying that this is obtained from me will not be considered. However, if I am doing some trials to find out where the workability, so that is allowed. So that goes on for the exceptions on section 29. Thus, the parallel conduct of the applicant is also to be looked into. So previous patent application and other application was based on obtaining it. So where the complete specification is filed in pursuance of an application made by a person being true and first inventor, shall not be deemed to be anticipated by reason only of any other application of a patent made in contravention of the rights to that person, or by reason only that after date of filing of the other application, this was used or published without the consent. So it's something similar. The previous one was about publication, and here it is about a patent filing. It says that if anybody contravenes my right, that without my consent, he goes and file another application. So that application, before I file my patent, so that will not be considered as a prior application or a prior patent, or even if that is published, so that will also not be considered as prior art. So these are on the obtaining, that is wrongful obtaining, or if it is published before 1912, 1st January 1912, these are not considered as prior publications which are anticipatory to the present invention. Now, if we go to the next provision, now this is what I was talking about, sorry, before going to the next, about the other side of the coin. I am the inventor, somebody has taken it, published it before me, I prove that it has been published without my consent. So that application is not considered. My patent is okay, it goes for grant. On the other side, the other person, I file a patent, it is published, and even if it is grant, another person comes and says that this patent, which is granted or about to be granted, has been obtained from him without his permission. So, accordingly, the patent cannot be granted to me. This is the other side of the coin. So, you see, obtaining is a very important feature. If it has been obtained from the applicant without his consent, that is not considered as an anticipatory document or anticipation if it is published. And for the opponent who is opposing a patent which has been granted or before grant, because in India we have oppositions before grant, after grant, even we have revocations. So in that, the opponent proves that the patentee or the applicant had actually obtained the invention from him without his consent, filed the patent in his name, and is going on about it. So, and if that is proved to be correct, then the said patent is liable to be revoked in favor of the revoked in favor from the favor of the applicant or patentee, and granted in favor of, the controller may allow that the patent or the application be proceeded in the name of the opponent from whom the earlier applicant had obtained. So, obtaining is a clause. So, obtaining is a clause which is helping the applicant to show that his invention is not anticipated, and it is helping the opponent to say that the application or the patent has been wrongfully obtained from him. Now, if we go to the next provision, it talks about the disclosure to the government or communication to the government. Now, for some purpose, you are disclosing your invention to the government of India. Now, that is not considered as a prior art or a prior publication, because for some reason, for some requirement, you had to convey it or you had to communicate it to for investigation into the merit of the invention or anything else. That's the purpose of certain. So one example would be for requesting permission. Now what happens when an inventor or the applicant who is Indian resident wants to file an application outside India? First application without filing in India. So for that purpose, he or the inventor or the applicant who is a resident of India has to take a permission from the Indian Patent Office. For that purpose, you have to give your invention details of the invention, and only abstract will not do. You have to give the whole detailed invention to the Patent Office. The Patent Office will check and then it will allow or disallow it to be filed outside. Why? Because the Patent Office or the Government of India wants to see that what invention is being filed outside. In case that is pharmaceutical compound, patent for say machinery, like we were talking about the textile comb, or a drug, or a paint composition, shampoo composition, something for the specs. So these things are not related to defense, but they have to see whether it is related to defense or related to atomic energy. And for the purpose, you disclose the invention to the government. And that is not considered as a anticipatory document later, because that time you have not filed. So you ask for the section 39, you have to ask for permission from the Patent Office. You submit this document within 2-3 weeks. The Patent Office gives the permission after reading it. And those documents you will never find that in the Patent Office website. So those are also not published. Yes? Any question? So for such investigation, if the document is disclosed to the Patent Office or to the Government of India, that is not considered as a disclosure for the purpose of taking away your novelty. Now, if we go another, this is the important section which we go about, is any display in an exhibition, which is in an exhibition or industrial or other exhibition, which exhibition has been listed in the government journal or gazette, or the publication any description in view of that display or exhibition, or the use of the invention is displayed on exhibition, and then during that time somebody publishes it without your consent, and the other is before the society. And for this, with 12 months you can apply for the invention, or what you call as the grace period. Unfortunately, there is no description of grace period, no description of transaction or learned society in the Patent Act. And neither do we have anything from the courts. Now, this is a very, what should I say, it is very much a gray area, because we do not know what the exhibition, or which are the exhibitions which are listed in the government gazette, because we are not aware of anything. And neither we are aware of what is a learned society before whom if I read my paper or it is published in the proceedings of, yes, or it is read or it is published before published in the proceedings or the transactions of that society with his consent. So this is a gray area, though it is called a 12 months grace period.
I
Or
request Jitendra Kumar to kindly mute his microphone. Mr. Jitendra Kumar, kindly mute your microphone, please. So, Sanchita madam, if you can kindly mute all from your side as a host, please, ma'am.
because I had already muted, just give me a moment. Just a moment.
So we shall continue now. Ma'am.
Yeah, I think he has muted also. This is a gray area, though people often ask us, like, what is the grace period in India? We do have a grace period of 12 months. That is, the inventor is publishing or the inventor is reading before the learned society, or inventor is displaying in an exhibition which is listed